Good evening and welcome to another session of the business law subject. During my past presentations, I showed to you all certain areas of company law, and today I wish to address some questions that have come in the business law paper of the Chartered Accountants. So let me first of all take you through the questions one by one and try to explain them and how to inform you all how you should answer the law questions. Let me take the first question, question 1 of the 2007 question paper. In question 1, it deals with a question relating to shares. Manik is the sole shareholder of Cinnamon Private Limited. The company is the owner of a cinnamon estate called Kurunduwatta. Manik took an insurance policy from Always Assurance PLC in his own name, covering the risk of landslides on this cinnamon estate. Subsequently, a landslide destroyed a part of the estate and Manik made a claim on his insurance policy. Now, what you have been required to do is to explain with reference to a decided case whether Manik will be entitled to the insurance claim. Now, let me first of all take you through the area of a company entering into a contract of insurance. Now, here the Manik, being the owner of Cinnamon Estate Kurunduwatta, is a sole shareholder of Cinnamon Private Limited. Now, the main matter that has to be addressed here is whether Manik has bestowed this cinnamon estate Kurunduwatta in the name of the Cinnamon Private Limited. Manik, being the owner, he has vested with this company, and the company is the owner of the cinnamon estate, and Manik, as a shareholder, took this insurance policy from Always Assurance Private Limited in his own name. Now, the issue here is that the insurance policy from Always Assurance PLC is in his own name, which means that the Manik is the insurer or insured in this respect, and not the company Cinnamon Private Limited. Manik has not taken this insurance in the name of the company, which he would have done so, although the company is the owner of the cinnamon estate. So, any company property has to take the insurance in the company's name, because the company is a distinct personality having, in fact, a legal personality in law, being a juridical person, and is outside any shareholder or a director operating in the company. So, the mistake that Manik has done here is that he has taken this insurance policy in his own name, thus covering the risk of landslides on this cinnamon estate. Subsequent to the landslide, where a part of the estate is damaged, Manik has made a claim on his insurance policy. Now, here the matter is that the insurer, who is the Always Assurance PLC, would take up the object in court that Manick does not have the title to the land, and therefore, even though the insurance policy has been obtained with respect to the estate, Manick cannot claim for this landslide, the part of the destroyed land caused by the landslide, and therefore, the insurer is not liable to pay the company nor Manick in this case. On one hand, the estate belonged to the company and the title of the estate remained with the company. And Manick, being a shareholder, has taken out the insurance policy in his own personal name on the other side, where to a land that he doesn't hold any title. Now, this is a clear distinction with a case of a privately owned vehicle, for example, or privately owned estate, where the insured has the title to such property. In this case, the insured doesn't have the title to the property. So, these are the primary matters that we have to attend to see whether Manick will be given the rightful claim. Now, let us go through our business law area that deals with the insuring aspect. Product of cut. Now, let me first of all have a look at the rights of shareholders and debenture holders in your syllabus. Now, it says that shareholders and debenture holders possess pivotal roles in relation to the ownership and continuity of a corporate body. However, the rights associated with each party constitute equal importance in maintaining the continual relationship between those parties and the company. Now, shareholders are those who are subscribed to the shares of the company. Shares are parts which form the equity capital, and in return, the shareholders are the owners of the company. Shareholders are invited to attend the annual general meeting of the company, and they have the right to vote. Shareholders are paid dividend on their holdings when there are sufficient profits made by the company. The dividend rates are not fixed and it is uncertain. Further, the shares are not secured investments. In case of winding up of the company, shareholders' funds are refunded after every claim is settled. Share capital is not returned except in case of redeemable preference shares. Now, you may see that within the rights of the shareholders, there is no such right conferred on a shareholder to obtain such insurance policies against a asset of the company. Put a hold kara. Now, let us have a look at the powers of shareholders conferred by the Companies Act. According to section 90, powers reserved to the shareholders of a company by this act may be exercised only at a meeting of shareholders by resolution in lieu of meeting. Powers reserved to the shareholders of a company by articles of the company may be subject to articles, be exercised at a meeting of the shareholders or by resolution. Now, unless otherwise provided by this act or in the articles of a company, a power reserved to shareholder may be exercised in an ordinary resolution. And it goes on talking about this particular resolutions. Now, we may see that here unless the powers are being conferred by special resolution or under the Articles of Association, a shareholder has no powers to enter into an agreement or a contract in his or her name on behalf of the company or on the company's assets. Now, therefore, we see that Manik, having entered into a insurance contract in his own name for the insurance of a company held estate, may not have been resolved or by way of an article empowered Manik to do so according to the question. Stop. Now, if we look at section 19 of the Companies Act, it deals with the company contracts, where it says a contract or other enforceable obligation may be entered into by a company as follows. An obligation which, if entered into by a natural person, is required by law to be in writing, signed by that person and be notarially attested, may be entered into on behalf of the company in writing, signed under the name of the company by two directors of the company. If there be only one director, by that director. If the articles of the association so provide, by any person or class of persons, or one or more attorneys appointed by the company and be notarially executed. Now, here we see that first of all, a company contract belonging referring to an asset of the company needs to be signed and entered by either two directors of the company, or one director if there is a single director company, or if the articles of the company so provide, then in fact a shareholder would be entitled, because by any person or class of persons, or one or more attorneys appointed by the company. So, these are the people who can sign on behalf of the company. Now, in this case, Manik has not signed on behalf of the company as per the question that has been posed. Now, also it says that an obligation which, if entered into by natural person, required by law to be in writing and signed by that person, and may be entered into on behalf of the company in writing, signed by a person acting under the company's express or implied authority. Now, it is also very clear that a shareholder or a director who is empowered to sign a company contract cannot sign by his personal capacity, but he has to sign on behalf of the company, and where the company has given the express or implied authority to such an undertaking. And also it says that in C, an obligation which, if entered into by natural persons, is not required by law to be in writing, may be entered into on behalf of the company in writing or orally by a person acting under the company's express or implied authority. Now, the interesting matter here is that generally insurance contracts have to be in writing. They are in the present context of the law, insurance contracts are in writing. So, therefore, it is mandatory for any person representing a company to sign such insurance policy or a contract on behalf of the company. Now, here the interesting case is this Makura versus Northern Assurance case, where it says that the properties of the company do not belong to the owner of the company. Now, this is a very interesting matter, very similar to that of the Manik's case. The Makura owned a timber estate. He sold the timber there to Irish Canadian Sawmills Limited, a company in which Makura was the sole owner with the nominees. He took out the insurance policies on the timber against fire with Northern Assurance in his own name and not in the name of the company. Now, this is a case which is identical to the Mannix case. Now, due to a fire, Northern Assurance refused to pay because the timber was owned by the company and not by McCory. Therefore, the company because the company was a separate legal entity, it was not bound to pay Mr. McCory any money. The House of Lords held that the insurance were not liable on the contract, since the timber that perished in the fire did not belong to McCory in his own insurance policy was held. As Lord Sumner said, it was not this, it belonged to the Irish Canadian Sawmills Limited. He stood in no legal or equitable relation to the timber at all, and his relation was the company, not its goods. So, now this is how you need to answer the particular question, where you highlight and stress on the important areas pertaining to the question. So, let us now go to the next question. Senadira, a director of XY Private Limited, has not been attending the board meetings of the company on a regular basis. Now, the shareholders of the company intend to remove him from the board of directors of the company. And what you are required to do is to explain the manner in which a director can be removed from office per the provisions laid out in Companies Act number 7 of 2007. Now, let me first of all go through certain areas that are important to address in the answer. Here it says that Senadira, a director of XY Private Limited. So, he is a director and has not been attending the board meetings of the company on a regular basis. Now, the shareholders of the company intend to remove him from the board of directors of the company. How can the shareholders do so? So, let us look back to the Companies Act on the removal of the directors. Now, the Company Act deals with the removal, appointment and removal of the directors, and I have very specifically dealt with this area in my lectures. So, the removal of directors are mentioned in section 206 of the Companies Act. Now, according to section 206(1), subject to the provisions contained in the articles of a company, a director may be removed from office by ordinary resolution passed at a meeting called for the purpose or for purposes that include the removal of director. Now, what is important here is that it says subject to the provisions contained in the articles. So, articles should be given the prominence in removing a director, and also thereafter, if it qualifies, then an ordinary resolution should be passed at a meeting of the shareholders called for that purpose. So, the shareholders meeting agenda should very specifically, or the notice rather, should very specifically mention that the meeting has been called for the removal of the director, and also stating these reasons. Because of the fact that I have dealt in the derivative actions, if this is not properly done so, the director will have an opportunity to file a derivative action in court. Now, that's what it says in subsection 2, is that the notice called in the meeting shall state that the purpose, or for a purpose of the meeting, is the removal of the director. Where notice is given an intended resolution to remove a director, and the director concerned makes representation within the period of 14 days of such notice, with such request to send copies to all shareholders, the company shall send copies of the said representations to all shareholders as well. If the representations are not sent due to company's default, the director concerned may require that the representations be read at the meeting. Thereafter, provided that the company may, with the permission of the court, obtain an order for cost to be paid by the director concerned, refrain from either sending such representations to the shareholders on reading the said representations at the meeting, where the company is able to satisfy court that the provisions of this section are being abused by the director concerned to secure unnecessary publicity for a defamatory matter. So, it is very much clear that the directors can be removed in such a manner, and the directors also in turn have the opportunity to be represented and to represent his facts in such a meeting. If he denies such opportunity, he could go for a derivative action. Now, in my presentations, I have also dealt how the directors can be removed. I would like to touch on that as well in order to make some few more clarifications. And you see here the directors and their disqualifications. How can a director be disqualified to act? Now, these are the areas where a director can be disqualified. Convicted of an offence punishable by imprisonment under the Companies Act, convicted of an offence involved in dishonest fraudulent act, a judge to be insolvent, a judge to be of unsound mind, prohibited by court of law to be a director, persistently fail to comply with the provisions of the Companies Act, and convicted of an offence involving dishonest fraudulent act abroad, being responsible as a director of a company that was declared insolvent. Now, what is important here with regard to our question is that if a director has persistently failed to comply with the provisions of the Companies Act. Now, let us have a look at that, where the company law requires a director to act in certain ways. Director's duties. In section 187, it says a person exercising powers or performing duties as a director of a company shall act in good faith and subject to subsection 2 in what that person believes to be in the interest of the company. A director of a company which is wholly owned subsidiary of another company may, if expressly permitted to do so by company's article, act in a manner which he believes in the interest of that company, even though it may not be the interest of the company of which he is a director. And also it says that the director of a company shall not act or agree to the company acting in a manner that contravenes any provisions of this act or the provisions contained in the articles of the company. So, and also that the directors have to maintain the standard of care expected of him. So, looking at all these things, if the Articles of Associations clearly states that the directors who are not acting in such a manner, and as per the question here, where the director has failed to attend regular board meetings, it shows his failure in doing the company matters in good faith as well as for the interest of the company, and also failing in his duty to maintain the standards of care. So, therefore, answering this question is very important that you deal with these respective sections in the Companies Act and justify your answer on how in the manner which the director can be removed from office under a general ordinary resolution, and the taken steps thereupon, where the director fails to act so. Now, question 2 is based on a matter where Benjamin is carrying on a printing business as a sole proprietorship. He wants to convert his business into a company in the form of either a company limited by guarantee or a private limited company. However, he has failed, he has the following main requirements. For the moment, he does not want to involve in any other parties as owners of the company. In the future, he may wish to have a limited number of members or shareholders in the company. Now, what you have been required to do is to explain from the two forms given above the type of company that is best suited for Benjamin's purpose. Now, before we look at the type of the companies here, let us see what Benjamin really wants. Now, we know that Benjamin is carrying on a printing business as a sole proprietorship. Now, this is the same situation what in Solomon and Solomon versus Solomon and Company, where Solomon underwent through doing a shoe producing business, and later on he converted that to a company and made also himself a majority shareholder as well as his family members the other minority shareholders. Now, here what Benjamin really wants is he doesn't want to involve in any other parties as owners of the company. So, it shows that he wants to be the sole shareholder of the company. And secondly, in the future he may wish to have a limited number of members, shareholders in the company. So, he wished to later on provide some people to own the shares of his company. Initially, he wants to operate as a sole shareholder company, and later on as a or rather opening the business and shares to the other shareholders. Here what is important is, under the company's law in this country, a private company at least need 2 shareholders to start. So, there is no way that a sole shareholder could start a company, a private company. But however, looking at the two possibilities, a company limited by guarantee or a private limited company. Now, here what is important is whether limited by guarantee or limited by shares. However, it is a private company that Benjamin will have to form. So, therefore, he being a sole shareholder will not be able to constitute a private company as a whole. So, even a guarantee company is where the shareholders give a guarantee at a time of winding up or other instances, the shares, the shareholders give the guarantee that their liability would be met, and also in a private limited company where the limitation, where the liability is limited by shares. But cardinally, it is the foremost requirement that you need to have 2 directors, 2 shareholders present in forming a private company, unless it's a public company. But here Benjamin, being a private person, has to form the company limited or guarantee with another shareholder in it. Now, let me further clarify it by the Company Act requirements on the formation of the company, formation of a company that is dealt in methods of incorporating. Here it says article 4(2), a company shall have not less than 2 shareholders, provided that a company may have a single shareholder, where such single shareholder is the Secretary of the Treasury, who is holding shares on behalf of a government of the government of Sri Lanka, or is an individual or a body corporate. Now here we know that it's the latter section deals with a public company, whereas any private company needs at least 2 shareholders. So going back to our question, it is clear that the advice that we can give to Benjamin is that he needs to have another person to operate, to constitute or to incorporate a company at initial stage, whether it is a limited liability company or whether it is a company limited by guarantee. So that should be the answer to this particular question. Now in B, Asha, an architect, intends to enter into a construction contract with ABC Private Limited. The company's articles allow the directors, by way of a board resolution, to authorize any officer to sign contracts on behalf of the company. The contract mentioned above was signed by the CEO of the ABC, who produced a resolution authorizing him to sign a contract. Asha now has a concern as to whether his resolution has been passed properly by the company. Now, what you are required to do is to explain to Asha the applicability of the Endo management rule in this instance and whether the contract is binding on the company. By nature, a company can only enter into a contract after obtaining the proper resolution, providing the signing powers as well as to providing the approval for the particular contract to sign. The only exception where a contract has been signed before the particular resolution has been granted is by a later ratification of the company stating that the contract so signed without or prior to passing of the resolution has been accepted and approved, because directors being agents of the company, the principal company can always ratify later the acts of such director, as long as the director has acted within the scope, or rather not going to the extent of committing an act of ultra vires. Now, further let me take you through the note where that deals with the internal management area. It is with regard to the company contracts. In section 19 of the Companies Act has set out the formalities that a company must observe when entering into a contract, and in terms of section 19(1), the legal requirements applicable for contracts that are entered into by natural persons are applicable to company contracts with the necessary modifications. Accordingly, an obligation which if entered into by natural persons is required by law to be in writing, signed by that person and to be notarially attested. Such an obligation may be entered into on behalf of the company in writing, signed under the name of the company by the two directors of the company, or where there is only one director, by that director, or if the articles of the company so provide, by any other person or class of persons or one or more attorneys appointed by the company and be notarially executed. So, when the obligation is required by law to be in writing, signed by person entering into it, a person acting under the company's express or implied authority may sign on behalf of the company, enter such obligation. Now, what is important here is this, in this question is the company's express or implied authority. Now, the implied authority is what matters here, and here further says the authority of directors, officers and agents to enter into contracts. It is it states that in terms of section 21 of the Companies Act, a company or a guarantor of an obligation of the company or person claiming under the company cannot assert the articles of the company have not been complied with against any person who has dealt with it or acquired rights from it. They also cannot assert that the persons named in the most recent notice filed under section 223 of the annual report delivered are not the directors of the secretary. Further, company holds out a person as a director, officer or agent of, it cannot assert that such person has not been duly appointed or does not have authority to exercise the powers and perform the duties that are customary in the business of the company or are normal for a director, officer or agent of a company carrying on business of the kind carried on by that company. A company also cannot assert that document issued by any director, secretary of the company or by any officer or agent with actual or normal authority to such issue such document is not valid or genuine. And also, however, it must be noted that these protections are now not available by a person who had the knowledge or should have had knowledge to contrary by virtue of their position with or in relation to the company. Now, what is important here is the Endo management rule. Now, under the common law, a person acting in good faith and without knowledge of any irregularity who is dealing with a corporation need not inquire about the formality of the internal proceedings of the company, but is entitled to assume that there has been compliance with the articles and bylaws. The principle known as the Endo management rule was authoritatively laid down in the 19th century case of Royal British Bank versus Turquoise, where it was held that a person dealing with a corporation has no obligation to ensure that a corporation has gone through any procedures required by its articles, bylaws, resolutions, contracts or policies to authorize a transaction or to give authority to a person purporting to act on behalf of the corporation. Constructive notice is a legal concept that signifies that person or entity should have known or as reasonable person would have known that fact even if they have no actual knowledge of it. The Companies Act of Sri Lanka has specifically dispensed the concept of constructive notice in terms of section 22, where it states that a person will not be affected by or deemed to have notice of knowledge of the contents of the articles of the company's documents merely because it is delivered to the registrar for filing or it is available at the company office for the inspection. Now, getting back to our question here, the company's articles allow the directors by way of a board resolution to authorize any officer to sign contracts on behalf of the company. So, the articles so provide that, and then also that the contract mentioned above is signed by the CEO of ABC, who produce a resolution authorize him to sign the contract. So, there is no problem in that respect. Now, Asha now has a concern as to whether the resolution has been passed properly by the company. Now, that is the question. So, in that case, this is the way that we have to answer whether the applicability of Endo management rule in this instance, whereas the contract becomes binding on the company having met the requirements as per the articles of association, as well as the law prevailing in the country. Now, let us look at the June 2017 paper. Here, the first question, A. Chatura Senarath is the Secretary to the Treasury of Sri Lanka. As a Secretary to the Treasury, he holds shares on behalf of the government of Sri Lanka in various companies incorporated under the Companies Act number 7 of 2007. So, what you are required to do is to explain whether it is possible under the Act, the two questions, for the Secretary to the Treasury to be sole shareholder of the company. Now, we have seen in the previous discussion that yes, it is possible under the company's law for the Secretary to the Treasury to be the sole shareholder of a public company, and a public company can be constituted by one director, and it can be done by the Secretary to the Treasury, but in the official capacity as the Secretary to the Treasury, not in the personal capacity of Chatura where he holds shares. But in the capacity as the Secretary to the Treasury, he can be the sole shareholder of the company, a public company, because it says here Chatura, he holds shares on behalf of the government of Sri Lanka. So, what is possible for him to do is, as the Secretary to the Treasury, he can hold shareholder to a public company. Then the second question is for Chatura Senarath in his personal capacity to be a shareholder of the company. Now, that is negative side of what we discussed. Now, here it is mentioned that Chatura Senarath in his personal capacity to be the shareholder of a company. The thing is that, now irrespective of the fact that Chatura is the Secretary to the Treasury, in his personal capacity as a person, there is no way that a sole shareholder company can exist. I told you before, a private company has to have two shareholders. And Chatura, if he forms a company, a public company, as a Secretary to the Treasury, yes, it is possible as a sole shareholder. But here, in his personal capacity, he can't be a sole shareholder of a company, because the companies have no, private companies have no existence with a sole shareholder. So, what the question asks is whether for Chatura Senarath in his personal capacity to be the sole shareholder of a company. Now, whether he is Secretary to the Treasury or not, Chatura himself cannot be a sole shareholder of a private company. It is very clear in that way that Chatura cannot become such a shareholder of a company. Now, if you look at the second question, Sumitra Fonseca is a registered company secretary. She now intends to join Sri Lanka Private Limited as its company secretary. What you are required to do is to explain to Sumitra, first of all, the role of a company secretary as laid down in Panorama Development Limited versus Fidelis Publishing Fabrics Limited, and also as to who will have the power to remove her from office of the company secretary. Now, if you look at the two questions, the first question is based on a particular case law. The second question is based on the company law. So, the first question is based on the common law, and the second question is based on the statutory law. Now, let me take you through to this role of the company secretary as laid down in the common law case of Panorama Developments Limited versus Fidelis Furnishing Fabrics Limited. So, if we go to the note, Your note states who is a company secretary. It says every company must have a secretary and the position forms an integral part of the administration of the company. The role of the company secretary therefore has to be considered in any discussion on the administration of a corporate body. In terms of section 221 of the Companies Act, the qualifications required for secretary may be prescribed by the registrar depending on the turnover and stated capital of a company and having regard to the nature of the duties that the secretary will be called upon to discharge. Before the secretary is appointed, the company must obtain such person's consent and the certification that such person possesses the required qualifications in a prescribed form. The board has the power to appoint or remove secretary unless the articles provides otherwise. The company secretary was treated a mere servant previously, but in the present context, the company secretary is considered an officer of the company having full capacity to enter into contract which will bind the company. Now, here the case of the Panorama Developments Limited versus Fidelis Furnishing Fabrics Limited has been discussed. The company secretary of Fidelis, Mr. Bain, hired cars from Panorama Developments business, Belgravia Executive Car Rental. Bain used the paper of Fidelis and represented that he wished to hire a number of Rolls Royces and Jaguars for the business while his managing director was away. He was lying and he used them himself. Bain was prosecuted and imprisoned, but Belgravia had outstanding £570 12 pence and 6 for the hired cars. Fidelis claimed that it was not bound to hire contracts because Bain never had the authority to enter into them. Lord Denin held that Fidelis was nevertheless bound to on the contract to Panorama. Mr. Bain, as company secretary, had ostensible or apparent authority to enter such agreements. A company secretary is a much more important person nowadays than he was in 1887. He is an officer of the company with extensive duties and responsibilities. This appears not only in the Modern Companies Act, but also by the role which he plays in the day-to-day business of companies. He is no longer a mere clerk. He regularly makes representations on behalf of the company and enters into the contract on behalf of which comes within the day-to-day running of the company's business, so that he may be regarded as held out as having authority to do such things on behalf of the company. He is certainly entitled to sign contracts connected with the administrative side of the company's affairs, such as employing staff and ordering cars and so forth. All such matters now come within the ostensible authority of the secretary of a company. Now, I would like to clarify this ostensible authority. Ostensible authority is where an agent of a company is believed to have the power of the principal company to, or the authorization to represent such company even in those contracts. Now, that is exactly what this question requires you to answer, where the role of the company secretary as laid down in this case, which we have now dealt with, especially the area of the ostensible authority that has to be addressed. Now, second part is dealing with as to who will have the power to remove her from the company secretary. Now, first of all, let me clarify that Sumitra Fonseca is a registered company secretary, means registered with the Registrar General of Companies. So, she is qualified, or she in this case is qualified. She is qualified to be in the company as required by the law join the Lanka Private Limited. So, under the Companies Act of Sri Lanka, the area of secretaries is dealing in section 225 onwards. So, we do not have a problem in the qualification, but on the removal, let us see how a secretary could be removed. The important section is that here under section 221 subsection 4, unless the articles of the company otherwise provides, the board shall have the power to appoint or remove a secretary of the company. So, it is the board that has the power to appoint or remove a secretary, unless anything to the contrary being said in the articles of association. The secretary of every company having turnover or stated capital of an amount prescribed here shall have the qualifications may be prescribed, having regard to the nature of the duties of the secretary will be called upon to discharge. So, here it deals with the qualification of secretary to be prescribed. So, now in terms of removing a secretary from office, since the company secretary plays an important role in the administration of the company, in the same manner that also where a secretary is empowered, likewise a director, as we saw in the case of Panorama Developments Limited versus Fidelis Furnishing Fabrics Limited. The secretary, company secretary can be removed in the same way as the removal of the directors, with an ordinary resolution being taken in a shareholders meeting and thereafter informing the registrar of companies, and unless a particular secretary resigns from office giving resignation, such a mechanism could be adopted in removing a company secretary holding office as the company secretary of the company, and inform the registrar accordingly by filling up the relevant forms and inserting a new company secretary in place. And generally these two actions have to be done simultaneously, so that the company's all affairs for which the recording responsibility remain with a secretary is thus filled, and there is no vacuum that would exist. Now, let us have a look at the next question. Ali and Benny were promoters of a company that deals in electric motor vehicles. Prior to the incorporation of this company, the promoters entered into a contract on behalf of the proposed company for the purchase of 75 electric three-wheelers. What you are required to do is to explain how the above contract can become binding on the company when the company comes into existence with reference to the provisions of the Companies Act. State 2 duties applicable to Ali and Benny as promoters in relation to the given scenario. And also to summarize 3 methods that Ali and Benny as promoters can utilize to reimburse the costs incurred by them to incorporate the company and to obtain payment for the services rendered by them. Now, first and foremost, let me explain to you the functions of a promoter, because the common law situation has now been changed by the statutory law in this country, the Companies Act number 7 of 2007, and I explained to you in one of my previous lectures also that the common law situation is no more valid under our statutory law. So, now here Ali and Benny were promoters of a company, which means that they were the promoters prior to the constitution or an incorporation of the company that deals in electric motor vehicles. Now, here what has happened is, prior to the incorporation of this company, these promoters Ali and Benny entered into a contract which is called a pre-incorporation contract on behalf of the proposed company. Now, the classic example of the case is the case of Kella versus Baxter. Now, what happened here? The promoters of a hotel company entered into a contract on its behalf for the purchase of wine. When the company formally came into existence, it ratified the contract. The wine was consumed, but before payment was made, the company went into liquidation. The promoters as agents were sued on the contract in their personal capacity. They argued that liability under the contract had passed by ratification to the company. It was held, however, that as the company did not exist at the time of the agreement, the contract would be wholly inoperative unless it was binding on the promoters personally, and a stranger cannot be subsequent ratification relieve them from that responsibility. Now, here what is important in this question is, first of all, to explain the above contract can become binding on the company. Now, under the common law situation that we saw here, it may not, but under the Companies Act, I would show you that the pre-incorporation contracts dealing with section 23 onwards section 23 states, for the purpose of this section and section 24 and 25 of this act, the expression pre-incorporation contracts means a contract purported to have been entered into by a company before its incorporation, or a contract entered into by a person on behalf of a company before and in contemplation of its corporation. And also, notwithstanding anything to the contrary in law, any law, a pre-incorporation contract may be ratified within such period as may be specified in the contract, or if no such period is specified, within a reasonable time after the incorporation of such company, in the name of which or on behalf of company which had been entered into. A pre-incorporation contract that is ratified under the subsection 2 shall be valid and enforceable as if the company had been party to the contract at the time it was entered into. A pre-incorporation contract that is ratified under the subsection 2 shall be valid and enforceable of the company. Pre-incorporation contract may be ratified by a company in the same manner as contract may be entered. Now, you see that the pre-incorporation contracts become valid after ratification by the company. Now, there are also warranties implied in pre-incorporation contract, where notwithstanding anything to the contrary in any law, in a pre-incorporation contract, unless a contrary intention is expressed in the contract, there shall be an implied warranty by the person who purports to enter into such contract in the name of or on behalf of the company, that the company will be incorporated within such period as may be specified in the contract, or if no period is specified, within a reasonable time after the making of the contract, and that the company will ratify the contract within such period as may be specified in the contract, or if no period is specified, within a reasonable time after the incorporation of such company. Now, what would be the circumstance in failure to ratify is where a company has acquired property pursuant to a pre-incorporation contract that has not been ratified by the company after its incorporation. A court may, on an application made in that behalf by the party for whom the property was acquired, make an order directing the company to return the property acquired under the pre-incorporation contract to that party, and validating the contract in whole or in part, or granting any other relief in favor of that party relating to the property acquired. Now, this is very important, because here it says where a company has acquired in section 25 property pursuant to a pre-incorporation contract that has not been ratified by the company after its incorporation. A court may, on an application made in that behalf by the party from whom the property was acquired, so the earlier owner, then the court can make the order directing the company to return the property acquired and validating the contract in whole or in part. Also, either directing the company to return the property acquired or validating the contract in whole or in part would also be possible, and also granting any other relief in favor of that party relating to that property so acquired. Now, here we saw in the Kella versus Baxter, the wine was consumed, but before payment was made by the company, went into liquidation. But however, the promoters purchased the wine. When the company was formally came into existence, it ratified the contract. So, it ratified the contract, but soon after went into liquidation. So, therefore, the promoters as agents were sued on contract, and it was held, however, as the company did not exist at the time of this agreement, would be wholly inoperative unless it was binding on the promoters personally. But now the situation is changed in the law, the Company Act, where validating the contract in whole or in part could be done by the court. So, now if we go back to the question, is where we explain how the above contract can become binding on the company. Later ratification is the way that makes it binding, and if such a situation happens as in the Kella versus Baxter case, then the Companies Act has provided in section 25 with regard to the failure to ratify. Now, the second question is state 2 duties applicable to Ali and Benny as promoters in relation to the given scenario. Now, in this scenario, what is important here is that Ali and Benny to very specifically mention that they are purchasing these 75 electric 3-wheelers on behalf of the proposed company, that they have done so, and also that they have the authority to do so, and they assume the ostensible authority of a principal company that is to be going to be incorporated, and upon ratification it would have the necessary legal binding. So, the two duties are that what Ali and Benny as promoters need to maintain. Summarize three methods that Ali and Benny as promoters can utilize to reimburse the costs incurred by them to incorporate the company and to obtain payment for the services rendered by them. Three methods. Now, let me get back to the section on the pre-incorporation contracts, the promoters especially. Here again, the duties of the promoter. Here as mentioned that the promoter must not make any secret profit out of the promotion of the company, as well as a promoter must make full disclosure of the company, as I mentioned. So, how they could recover their promotion costs and services? The three methods are mentioned here. Therefore, the following methods are being used to reimburse the promoter for the cost incurred by him for the services rendered. Payments clause is included in the articles of the company, permitting the payments to a promoter for costs and services rendered by him. However, the promoters have no right to compel the company to effect such payment. The promoters are given the option to buy a specific number of shares from the company at the nominal value with an agreed period of time. If after the formation of the company, the share price of the company increases, the promoter can exercise his option and purchase such number of shares at the nominal value, thereby making a profit which will set off his expenses relating to the promotion of the company. The promoters may be allowed to make a profit by entering into transactions with the company and thereby cover the promotional costs incurred by such promoter. But in such event, a proper disclosure of the profits is an essential requirement. So, these are the three methods that can be utilized by promoters in this respect. The next question that I would like to address is question 3. Abu Bakr, a businessman, has been invited to invest in Davidson Private Limited. He has also been given the choice of holding either ordinary shares or preference shares in this company. What you are required to do is to outline the features of ordinary shares and preference shares. So, you need to address here the areas that have been discussed in your note as well as in the Companies Act that deals with the types and classes of shares. Firstly, it is important to mention Article 49 that says that the share in a company shall be movable property. And also a company here may issue different classes of shares, and in particular may issue shares which are redeemable, confer preferential rights to distributions, confer special limited conditional voting rights or confer no voting rights, and so forth. And also that the shares are transferable. Now, in your note also you will find that the types of shares. Firstly, the ordinary shares. The basic form of shares is ordinary shares. Most companies have just ordinary shares, nothing else. Ordinary shares vest the owner with 1 vote per share, entitlement to participate equally in dividends, and if the company is wound up, share in the proceeds of the company's assets after all the debts have been paid. Holders of ordinary shares have a right to unrestricted participation in the dividends of the company and to the distribution of its remaining property. The risk is that holders of ordinary shares will be entitled to dividends only if the company makes profits. And preference shares, in terms of section 49(3)(b), a company can issue shares having the ranking above ordinary shares in specified aspects. Preference shareholders have a priority to a fixed dividend and to a return of capital in a winding up. These usually confer rights and preferential dividends, which may be cumulative or non-cumulative. The general rule is that shares rank equally. The terms relating to preference shares have to be clearly stated at the time of issue. And then the deferred shares. These shares are issued with limited rights. In a modern world company, the tendency is not to issue deferred shares. The fact that the deferred shares have no right of dividends during a particular period does not mean that there are ordinary share capital. Deferred shares are often created for commercial reasons to enable the private sector investors to take capital growth instead of dividends income. They are generally issues to founders and directors of the company. These shares receive no rights to a company's remaining assets in the event of bankruptcy until all common and preferred shareholders have been paid. Then also you have the non-voting shares. In terms of section 49(3)(c), companies may issue shares which do not carry voting rights at all, or which carry limited rights of voting in specified situations as set out in the Articles of Associations. And these are also issued by public listed company. And then the remedial, the redeemable shares that are created on the understanding that they will not be bought back by the company. The redemption may be at the option of the company or the shareholder, or on a fixed date or upon the occurrence of an event. The price at which shares must be redeemed may also be specified either on the basis of a predetermined price formula. So, going back to our question, then we see that the features of ordinary shares and preference shares have been discussed. In addition, I spoke about the other three categories, which are not that important to discuss here, but the features of ordinary shares and preference shares that do have a direct impact on the company are important to be discussed. Now, the next question, the Articles of Suryakanta Private Limited contains a clause as follows: all preference shares of a company shall be redeemed on the second anniversary of the company, and the consideration shall be paid at the time of such redemption. The consideration shall be computed based on the net asset based value per share. The directors of SPL now wish to know whether the above clause in this article is legally valid and enforceable. Now, what they have been required to do so is compare the above clause with the relevant provisions of the Companies Act in order to answer the query of the directors. Now, I happened to discuss this area as the redeemable shares earlier. Redeemable shares are created on understanding that they will be bought back by the company. Now, how? Their redemption may be at the option of the company or the shareholder on a fixed date or upon of occurrence of an event. And the important thing is that the price at which shares must be redeemed may also be specified either on the basis of a predetermined price or formula. That is at the end, at the time of entering these redeemable shares. Now, let us see what the Companies Act say in this regard. Here it says a company may issue different classes of shares and the redeemable under section 49(3)(a). And here under section 63, it deals with the repurchase. A company may purchase or otherwise acquire any of its own shares under these sections if a company or private company with the agreement or concurrence of shareholders and so forth, but not otherwise. Then there in subsection 2 it says a company may redeem a share which is redeemable share in accordance with the provisions of section 66 to 69, but not otherwise. Now, let us have a look at section 66 and 69, where it deals with the redemption of shares. For the purpose of this act, a share is redeemable if the articles of the company make provision for the redemption at the option of the company, at the option of the holder of the shares, the date specified in the articles. And for a consideration that is specified to be or calculated by reference to a formula or required to be fixed by a suitably qualified person who is not associated with or interest of the company. A company may exercise an option to redeem a share which is redeemable at the option of the company if the board had previously resolved the redemption is in the interest of the company. So, redemption is in the interest of the company. And a redemption of shares at the option of the company is acquisition by the company of the shares and the distribution, and if it is in the option of a shareholder to redemption on fixed date, and company shall redeem the shares on that day and the share is deemed to be cancelled on that day. And for the date the former shareholder rank as unsecured creditor of the company for the sum payable on redemption. Now, the question here is the all preference shares of the company shall be redeemed on the second anniversary. The consideration shall be paid at the time of such redemption. The consideration shall be computed based on the net based value per share. The directors now wish to see whether the above clause in the article is legally valid and enforceable. The question is that. So, since the question is based on the fact whether this particular statement is legally valid in the articles of association. Now, what the question here is that the preference shares of the company shall be redeemed, and What are these preference shares? Preference shareholders, these having a ranking above ordinary shares in specified aspects. Preference shareholders have priority to a fixed dividend and to return of capital in a winding up. These usually confer rights to preferential dividends, which may be cumulative or non-cumulative. But here, redeemable shares are created on the understanding that they will be brought back by the company. So, there is and maybe redeemed at the option of the company or shareholder. So, comparing the preference shares with the redeemable shares, it is only on the option of a shareholder that these preference shares be redeemed. So, all preference shares of the company shall be redeemed on the second anniversary of the company, and the consideration shall be paid at the time of such redemption based on computed value. Is here what is the most important thing being shall be redeemed is legally invalid and not enforceable according to the clarifications that I mentioned. So, for today's lecture, I have dealt with these questions, and I hope that you may now be able to do your answering accordingly. Make sure to understand the question very carefully and answer appropriately and relevantly to what has been answered or what has been questioned. And in law, you need to touch upon the sources that are the statutory provisions such as the company law as well as the case law that also we have discussed. Thank you very much.